Hearing the appeals of Patel and Shah against Secretary of State for the Home Department.
Yes, Mr. Ray.
My Lady, I appear for the appellant, Mr. Patel, with my learned friends, Mr. Rowan Pennington-Benton and Mr. Ahmad Badar. The appellant, Mr. Shah, is represented by Mr. Malik and Mr. Darrell Balroop. The respondent by our learned friends, Mr. David Blundell and Ms. Julia Smythe. There are also, as your ladyship knows, two interventions for which the court has given permission, one from the Air Centre, on whose behalf Mr. Drabble, Queen's Counsel to my left, will speak in due course, supported by Mr. Banner and Bojana Azdanovic, and there are written submissions from Ms. Gallagher for Liberty, which I'm sure the court will have looked at as well.
But it's good to see her in court anyway.
Absolutely. My Lady, the scheme of my submissions, subject, of course, to any diversions from my intended route, which the court might want to take me on from time to time, which, of course, no doubt you will if you wish to, is broadly this: to look at the law and to set out our submissions as to where we say the Zambrano principle now stands, both as a matter of authority and, as I shall submit, as a matter of its inherent logic. Secondly, to draw attention to some aspects of the facts in Mr. Patel's case. We will submit really quite remarkable facts in Mr. Patel's case. And then thirdly, to consider how that was dealt with, how the law and the facts were dealt with by the judge in the first tier tribunal, and how we submit that approach was wrong, and how that it wasn't put right at any of the subsequent stages we submit in the case. So, Lady, as far as the law is concerned, the principle is not, of course, an unfamiliar one to this court. In fact, my researchers are right, I don't believe there's a single member of today's constitution of the court who hasn't had to consider at least one Zambrano appeal, either in this court or as she then was, as they say, at some stage. So I'm not in those circumstances going to try to take the court through all of the Zambrano cases, of which there are quite a few. But I hope the court will forgive me if I go back to a couple of cases and, albeit pretty briefly, seek to go back to first principles. Not least because it is suggested by our learned friends for the Secretary of State that the Zambrano principle, as they put it in their printed case, exists at the very edge of EU law, which we submit as a proposition that misses the mark by some way and might be liable to lead to an instinctively restrictive application of the principle, looking for only the exceptional case. And we submit that's not quite right. So the starting point we submit is to go to a principle which is actually at the very centre of EU law as opposed to community law, namely the citizenship of the idea of citizenship of the Union. That was described by the President of the Court of Justice in a paper that we mention in our printed case. I won't go to it now in view of the time, but time constraints. But it was mentioned in a paper that the President of the Court gave a couple of years ago to the Bar Council as one of the key aspects of the story of EU integration. And it was established, of course, in 1993, or came into force in 1993, by what is now Article 20 of the Treaty on the Functioning of the European Union, the FEU. And can I just ask your Lordship and the Court to turn that up? It's at page 951, or if one's using the paper version, Primary Authorities, Volume 1, tab 17. If we have that, we can see Article 20, X Article 17 TEC, citizenship of the Union is hereby established. Every person holding the nationality of a member state shall be a citizen of the Union. Citizenship of the Union shall be additional to and not replace national citizenship. Citizens of the Union shall enjoy the rights and be subject to the duties provided for in the treaties, and they shall have inter alia, and A is the important one for present purposes, the right to move and reside freely within the territory of the member states. And there are other rights set out at B, C, and D, all to be exercised in accordance with the conditions and limits defined by the treaties and by the measures adopted thereunder. And that conferral of a right is essentially repeated in Article 21 at paragraph 1. Every citizen of the Union shall have the right to move and reside freely within the territory of the member states, subject to the limitations and conditions laid down in the treaties and by the measures adopted to give them effect. And of course, Article 21 then goes on to give competence to the community, the Union institutions to enact legislation at the Union level to give effect to that right, and to that citizenship. That's a convenient way, perhaps, to go straight into Zambrano itself. It's a development. The institution of EU citizenship is a development which is commented on by Advocate General Sharpston in her opinion in the Zambrano case. My lady, the Zambrano case in the paper volume we find behind tab 12, page 859 on the computer.
Sorry, 8?
859.
Thank you.
I'll come on in a second to the facts of Zambrano, familiar though of course they are. But I wanted just to pick up that reference to what the Advocate General had to say, and we can see that at page 877. And she says at paragraph 67 that the Maastricht Treaty introduced European citizenship as a novel and complementary status for all member state nationals, by granting to every citizen the right to move and reside freely within the territory of the member states. The new treaty recognised the essential role of individuals, irrespective of whether or not they were economically active within the newly created European Union. And she picks up a number of authorities that will be familiar to the court, at least the general principle will be, to the effect that that status as citizen of the European Union is, in the words of the European Court of Justice, destined to become the fundamental status of nationals of the member states. And the Advocate General says at 68 the consequences of that statement are, she suggests, as important and far-reaching as those of earlier milestones in the court's case law. And she refers to the well-known Van Gent and Loos case and its declaration about the community having established a new, or constituting a new legal order for the benefit of which states have limited their sovereign rights. So, while of course what one Advocate General says is not necessarily the same thing as what the law is, it's we submit an important point that the foundation of the Zambrano doctrine is something which is regarded there as a very important milestone in the development of European integration. It's not, we submit, something which derives from anything at the edge of EU law or as a kind of exception to the ordinary way of things, although I appreciate that for reasons we'll come on to, in some sense, of course, Zambrano cases are exceptional cases. The facts of Zambrano were, of course, very simple. In that case, the parents were together, and they both faced the same prospect of leaving the EU if they couldn't get a residence permit in Belgium. And as I read it, if one looks at page 908, the children were very young indeed when the applications for resident permits were made. We look at the bottom of 908. Diego, who was the first of the couple's Belgian children, was born on the 1st of September 2003. That's paragraph 19. And at paragraph 22, Jessica, their third child, but their second Belgian national child, was born on the 26th of August 2005. Sorry, yes. And then on the 2nd of September 2005, they lodged their application to take up residence under the Belgian law. So it's an application for residence made the day after Diego has celebrated his second birthday. And when Jessica is only 7 days old. Now, if one then looks to the relevant part of the decision itself, it is perhaps unsurprisingly in those circumstances relatively brief, and we pick that up at paragraph 40, if we may, which is 912. And by this point, the court has rejected suggestions that the secondary legislation applies, because it's not, in fact, a case involving any movement between EU states. But they refer to Article 20, which we just looked at, and the fact that it confers the status of citizen of the European Union on every person holding the nationality of a member state. They repeat the point about citizenship being intended to be the fundamental status of all nationals of member states. The consequence of that is that 42, the treaty, that paragraph in the treaty, that provision in the treaty precludes national measures which have the effect of depriving citizens of the European Union of the genuine enjoyment of the substance of the rights conferred by virtue of their status as citizens. And then the application of those general propositions to the particular problem is expressed in very concise terms, essentially in these following paragraphs. They simply assert that a refusal to grant a right of residence to a third country national with dependent minor children in the member state where those children are nationals and reside, and also a refusal to grant such person a work permit, has such an effect, that is to say, has an effect of depriving them of the genuine enjoyment of their rights as EU citizens. Why? Well, paragraph 44, it must be assumed that such a refusal would lead to a situation where those children, citizens of the EU, would have to leave the territory of the EU in order to accompany their parents. Likewise, not granting a work permit, in those circumstances, those citizens would, as a result, be unable to exercise the substance of the rights conferred on them by virtue of their status as citizens of the European Union. So the focus is very much on the genuine enjoyment by the EU citizen of the substance of the rights conferred as such. It was obvious in that case, as a matter of fact, that the removal of the parents, or the departure of the parents, if they didn't have to be forcibly removed, but went voluntarily, in the sense that they complied with the legal obligation to leave, would oblige the children to leave. And for what it's worth, and I don't put a strong emphasis on it, but for what it's worth, the original text of this judgment is French, and the French verb that's used is obliger. Les enfants se verront obligés de quitter le territoire, etc. Since we're on linguistic points, I should also say that one might read 44, it must be assumed that as being some sort of legal proposition that's being put down, but in my submission, it's simply a statement of fact that in that particular case, it surely follows from the removal of the parents or the departure of the parents that the children will also leave. For what it's worth, the French text was il doit en effet être considéré que, etc., etc. So on the face of it, it's a straightforward matter, but it's important in our submission to keep in mind that when the court spoke about the children being obliged to leave the EU if their parents left the EU, it was, albeit perhaps very unnoticeably on those facts, making a judgment which had an element of value judgment in it, and not simply making a pure factual finding or a pure factual prediction. And I say that because the only people who are actually at risk of being physically hauled out of Belgium were the parents, Mr. and Mrs. Ruiz Zambrano. There would be no basis upon which the children themselves could themselves be removed. The children would go in practice, of course, because their parents took them. But as a matter of law, I would submit the children would go because their parents would decide on their behalf that they would go. So in other words, a choice would be made on the children's behalf. I say a choice, but of course it's not much of a choice. Theoretically, though, a different choice could have been made. The parents could, in theory, have chosen to leave without their children. Or in other words, to choose on their children's behalf, if we're being strictly accurate about it, that the children should remain behind. And no doubt if that had happened, then the Belgian state would have done whatever the Belgian state does for abandoned children, looked after them in some fashion. Of course, in that case, it was never going to happen. It was simply unthinkable. And it doesn't really occur to us to articulate the idea that a choice of any sort is being made. But I do submit that implicit in this is an element of choice. It's simply that in those circumstances, it's a choice which, in all sensible terms, is not really a choice at all, because the alternative is so unacceptable. But if that case is at one end of the spectrum, as it were, in terms of the clarity of the facts, the next one I want to mention is at the other, and that's Dept, which you can find at tab 6 in the paper version, page 652. This was the case where, instead of a couple being unlawfully in the EU with their children, it was a man who had an Austrian wife and Austrian children. And could he insist on staying in the EU on the ground of Zambrano, his treaty, or their treaty rights rather, on the ground that they would otherwise have to leave? Well, the court gave fairly short shrift to his arguments, and we can see that if we jump in at paragraph 66, which is at 686. Just before we get there, the court has done what the European Court so often does, and has recited essentially verbatim some of its previous learning on and rulings on the subject. It told us about Zambrano. And then at 66 says it follows that the criterion relating to the denial of the genuine enjoyment of the substance of the rights conferred by virtue of EU citizen status refers to situations in which the Union citizen has, in fact, to leave not only the territory of the member state of which he is a national, but also the territory of the Union as a whole. Over the page, that criterion is specific in character inasmuch as it relates to situations in which, although subordinate legislation on the right of residence of third country nationals is not applicable, a right of residence may not exceptionally be refused to a third country national who is a family member of a member state national, as the effectiveness of Union citizenship enjoyed by that national would otherwise be undermined. We accept, of course, that the court there uses the word exceptionally, and in a sense, Zambrano lays down an exception to ordinary principles about who can and cannot be in any given member state, which is, as regards third country nationals, so-called non-EU citizens, a matter for the EU state generally, and for the member state, and not for the EU. But nevertheless, although it's an exception in that sense, it still, as we see here, derives from the fundamental point that there exists now this status of Union citizenship. The dismissal by the court effectively the dismissal by the court of the case, I appreciate it's a reference, so technically it's a matter for the lower court, but the dismissal effectively of the case comes in paragraph 68. Consequently, the mere fact that it might appear desirable to a national of a member state for economic reasons or in order to keep his family together in the territory of the Union, for the members of his family who do not have the nationality of a member state to be able to reside with him in the territory of the Union is not sufficient in itself to support the view that the Union citizen will be forced to leave Union territory if such a right is not granted. So it makes it clear that it's not sufficient simply to say, well, it is desirable for the non-EU citizen to stay for the benefit of the EU citizen. It's always to be looked at, we would submit, from the perspective of the EU citizen, because it's the EU citizen's rights which are under consideration. The ability of the EU citizen to enjoy those rights genuinely is under consideration. But that was a case where the court was able to lay down that distinction that mere desirability is not enough, and looked at from the perspective of the EU citizen. If we just take the two cases we've seen so far, the contrast is between Zambrano, where the EU citizens had no one in the EU for them. They were a babe in arms and a toddler, both of whose parents were at risk of being removed from the EU. And this case, where on the facts the EU citizens in question had their mothers present, their mother present, and it was the father's departure which was in issue. I submit that that's rather at the opposite end of the spectrum, but it doesn't undermine my point about the need to be, at some stage, a degree of judgment about what's really meant by choice. But that was clearly a case where any departure from the EU by the EU citizen would plainly be a matter of choice. Skipping then through the cases, the next one I wanted to mention is tab 10, or page 817. I hope you'll forgive me if I call it the case of O. And that is to similar effect in terms of facts, although the facts are a little more complicated. We can pick it up from the head note on 817. In each of the two cases, the third country national woman. I've been trying to stick to calling what's described often as the third country national as the non-EU national, because it seems to me in a case where we're not talking about moving between one EU state and a second EU state, it's not entirely helpful necessarily to talk about third country nationals, but that's the terminology that's often
But third
used.
country national almost invariably refers to a non-EU
Yes.
national.
No, I just mean I agree, as a matter of language. I'm just saying that for the purposes of espousing the principle, it may be clearer to talk about non-EU citizens. Anyhow, either way, third country national woman married a Finnish husband, obtained a permanent resident permit in Finland. Each woman gave birth to a child of Finnish nationality over whom she had sole custody. Following divorce from her husband, who continued to live in Finland, each woman subsequently married a third country national, and each had a second child who did not have Finnish nationality. And the Finnish Immigration Office refused applications for resident permits for the third country national husbands on the ground that neither had secure means of subsistence. That was the context in which this arose. And just below letter F, we can see the court, that's the Finnish court, raised the issue as to the applicability in the particular context of a reconstituted family in which the applicant had no parental or financial responsibility over the union citizen child, at the established principle that we've seen. In other words, the principle that Article 20 precludes national measures which have the effect of denying unions the genuine enjoyment of the substance of their rights. If we go in that case to paragraph 51 of the judgment, which we can find at page 840, we can see how the court dealt with the issue here. In fact, I should probably start a little earlier on that page. We have, again, 45 is really where we come into looking at the Zambrano point, the usual recitation of the previous case law. Paragraph 49, in the present case, it is for the referring court to establish whether the refusal of the application for residence permits submitted on the basis of family reunification in circumstances such as those at issue in the main proceedings entails for the union citizens concerned a denial of the genuine enjoyment of the substance of the rights conferred by their status. When making that assessment, it must be taken into account that the mothers of the union citizens hold permanent resident permits in the member state in question, so that in law there is no obligation either for them or for the union citizens dependent on them to leave the territory of the member state or of the European Union as a whole. And then the court sets out in paragraph 51 some other aspects of the facts of that case and how those facts should be dealt with for the purpose of examining whether the union citizens concerned would be unable in fact to exercise the substance of the rights conferred by their status. The question of the custody of the sponsor's children and the fact that the children are part of reconstituted families are also relevant. First, since Ms. S and Ms. L have sole custody of the union citizens concerned, who are minors, a decision by them to leave the territory of the member state of which those children are nationals in order to preserve the family unit would have the effect of depriving those union citizens of all contact with their biological fathers, should such contact have been maintained up to the present. Secondly, any decision to stay in the territory of that member state in order to preserve the relationship, if any, of the union citizens who are minors with their biological fathers would have the effect of harming the relationship of the other children who are third country nationals with their biological fathers. And then we see a repetition of the Dept point in the next paragraph, the mere fact that it might appear desirable for economic reasons or in order to preserve the family unit in the territory of the Union for members of a family consisting of third country nationals and a Union citizen who is a minor, to be able to reside with that citizen in the territory of the Union in the member state of which he is a national, a long clause, is not sufficient in itself to support the view that the Union citizen would be forced to leave the territory of the Union if such a right of residence were not granted. And the National Court is told at 53, in connection with the assessment mentioned in paragraph 49 above, that's the assessment of whether the substance of the rights will be infringed, which it is for the referring court to carry out, that court must examine all the circumstances of the case in order to determine whether, in fact, the decisions refusing residence permits at issue are liable to undermine the effectiveness, etc. 54 says that whether the person for whom a right of residence is sought on the basis of family reunification lives together with the sponsor and the other family members is not decisive. 55 tells us that it's not essential that there be a blood relationship. And then 56, which contains something that's picked up later on in other cases, we can see says, on the other hand, both the permanent right of residence of the mothers of the Union citizens concerned who are minors and the fact that the third country nationals for whom a right of residence is sought are not persons on whom those citizens are legally, financially, or emotionally dependent must be taken into consideration when examining the question whether, as a result of the refusal of a right of residence, those citizens would be unable to exercise the substance of the rights conferred by their status. So it's necessary in this context, says the court, to look at, amongst other questions, whether who is legally, financially, and emotionally dependent on whom. The emphasis is on dependency, and to what extent is there dependency, and what sort of dependency is it. And they go on to say, as the Advocate General observes in point 44 of his opinion, which I haven't taken you to, but we can pick it up from here, it is the relationship of dependency between the Union citizen who is a minor and the third country national who is refused a right of residence that is liable to jeopardize the effectiveness of Union citizenship, since it is that dependency that would lead to the Union citizen being obliged, in fact, to leave not only the territory of the member state of which he is a national, but also that of the European Union as a whole. And subject to, they then say, subject to the verification which it is for the referring court to carry out, the information available to the court appears to suggest that there might be no such dependency in the cases in the main proceedings. And you'll recall the facts from the head note that I looked at earlier. So in a sense, that is, we would submit a case rather like Dept on the facts, in the sense that it's not at the Zambrano end of the spectrum where you have a babe in arms, and the question is, should we remove the mother and father, and in those circumstances, can it really be said that the babe in arms has any choice but to go with them? But what's important is the fact that, perhaps by virtue of the slightly greater complexity of the facts here in the O case compared perhaps to Dept, because of the way in which there had been these reconstituted families, the European Court starts talking about, or talks here anyway, about I don't claim it's necessarily for the first time, talks about legal, financial and emotional dependency. I don't dispute, of course, that in all the cases I've looked at, I've taken your relationship to, the European Court speaks in terms of a factual inquiry. That, of course, is the Secretary of State's main point in response to this appeal. Well, it's just a matter of factual inquiry, and really this doesn't come into it. But as the factual inquiry being, would the departure of the non-EU citizen oblige the EU citizen to leave the EU? But implicit in this, I do submit, pregnant in it as it were, is a judgment about what it means to oblige someone to leave. And since we're not concerned in the case of the EU citizen with any physical compulsion to leave, such as would be the case with the third country national, who, if necessary, can ultimately be visited at home by some burly employees of the Home Secretary and removed forcibly. We are really concerned with the question whether departure of the non-EU citizen would leave the EU citizen with any real choice in the matter, and that does open up a broader sort of inquiry. I appreciate that's not really how it's put in the case law that I've shown the court so far, nor indeed entirely in the case law that I'm about to come to, but that is what is, in my submission, lurking under the surface, and in any event, I'll come on to demonstrate, I hope, in a moment, that the further case law does compel an inquiry that does address some questions that one might, to some extent, say are value-laden and not simply ones that can sensibly be spoken about as pure factual inquiries. And we mentioned in our printed case that one could imagine more complex scenarios still.
I mean, if you're leaving,
yes,
there are all sorts of factors which are mentioned if one's, and I'm just wondering what their relevance is. I mean, paragraph 51, there's quite a lot of sort of talk about the biological parents and the link with them. And what's that got to do with it? I mean,
well, it's got...
Can you extract any sort of coherent test from this, other than throwing out a whole lot of facts and saying, well,
one needs to look at, first of all, yes, in the sense that one needs to look at all of the facts. I appreciate that's only a very partial answer to your Lordship's question.
I know you do that.
because the question is, what do you do with that once I accept that entirely, once you've got that far. Well, the coherent test that I'm seeking to extract from it is that looking at all of those facts, including emotional, financial, and legal dependence, you have to analyse intensely the nature of the alleged dependency. And having done that, you ask yourself, would the EU citizen be obliged to leave the EU? Not simply by asking yourself, well, what actually would happen if the authorities went in and hauled the EU citizen out, so hauled the non-EU citizen out, but by looking in terms of the.
How does a potential relationship with the biological parents come into it? Biological fathers in paragraph 51. I mean, that seems to be making a sort of judgment about what is desirable to say. Well, it's obviously desirable that they should have the chance of such a relationship. But I mean, what's that got to do with your test?
Well, what it's got, because it goes to my point about the distinction between, and we'll come on to this in the way the Court of Appeal dealt with it in the present case, the distinction between choice and compulsion. And it becomes, when you've done the exercise of looking closely at all of the facts, including what one might call emotional facts, dependency, and all of the aspects of the dependency, when one is then presented with the need to decide whether the departure of the EU citizen from the EU would be a question of choice or compulsion, then there is a degree of value judgment that comes into it, because there are some respects in which, bearing those values in mind, it doesn't really make sense to talk about the person having a choice. That's why. Excuse me.
Sorry,
no, I was going to say that's why instinctively in Zambrano case one just says straight away, well, of course it would force the 7-day-old baby to leave if her mother is required to leave, because the facts there are so clear cut that one can skate over the reasoning. One's just almost a shorthand for she would have no choice but to leave. But
it seems possible to read paragraph 51 as simply outlining the dilemma, doing no more than that, and then leading on to the desirability is neither here nor there in 52.
Well, except that the opening sentence,
except for the opening sentence,
says that various things are relevant for the purpose of examining whether the Union citizens concerned would be unable, in fact, to exercise the substance of the rights conferred by their status. So I'm not sure one can read it down quite so effectively, my lady, because what 52 is doing is distinguishing the case where it is merely desirable that the people stay together, that the family unit in that case is preserved.
It's quite a strong sense of desirable, though, isn't it? People don't usually leave their small children behind if they have to leave the country.
My lord, that's right. But one always has to look at the particular facts of the case. And I mean, the finding here appears to be, or insofar as this court makes findings, subject to that limitation, we're talking about looking at what they say at 57, is that this is a case where it might merely be desirable. But of course, they've made the point in 51, actually, that because of the curious nature, or perhaps unusual nature of this family, a reconstituted family, there are factors that cut both ways. But I mean, I accept that they use it may appear desirable in a sense to cover things that would perhaps appear very desirable to some people. And it's not just for economic reasons, but it's to preserve the family unit, which is clearly in most cases an important point.
So the word desirable is also a value judgment, but how do you know what weight to give to the various factors?
Well, you have to take into account, this is why we'll come on in due course to look at what was said in Chavez Vilches, but you have to take into account some of the values that you are applying when you give effect to these to this jurisprudence, and ultimately, the court simply has to take a decision on the basis of all of the facts as to whether in those circumstances it's really right to talk about it being a question of choice or compulsion. But can I...
Anything said in O about whether these mothers would have left Finland had their second spouses been denied residence?
I don't think there's...
With which we're concerned in the Shah case.
Sorry, related to the question, is there anything said as to whether they would have left?
Yeah.
I don't think there is any...
I haven't seen anything.
No, I don't think there is any direct finding, as it were. I mean, it's a finding.
There's nothing
finding
particularly
of
special about the dispositif, which merely repeats the principle.
Yes, except that we get at 57 that it appears to the court that there might be no such dependency, which suggests that they thought the answer was that they probably wouldn't leave, but we don't know that, and it's not clearly set out. But I was going on to say that one could envisage more complex or other complex scenarios. If we imagine, for example, a single non-EU citizen who is the parent of an EU citizen child, but and as a non-EU citizen, the parent is liable to removal from the Union. But there's an EU citizen grandmother, let us say, who is hale and hearty and knows the children well and is happy to provide, knows the child well, happy to provide for the child and provide a home for the child if necessary. Now, I mean, in those circumstances, the evidence might perhaps be, well, if the parent is forcibly removed, then the grandmother will take over. So when the parent says, well, don't remove me or you will force my child out of the EU, which is essentially the plea that's made in these cases, that can a tribunal say, well, no, it won't force the child out because the child can go to the grandmother. It might be desirable to stay with the parent, but it's not necessary. So if the child leaves, it's really a matter of choice. In other words, actually a matter of the parent choosing on the child's behalf to take the child. Well, it depends, again, on how you approach the question of
What's your
compulsion.
answer? What's your answer in that case?
Well, my answer, as far as this for the purposes of this appeal, my answer is that you need as a tribunal to face up to
I know
the dilemma that
need
you're
to
being
do.
given.
What would you do? The case you're putting to us, which is an interesting case with the grandmother who's perfectly capable of looking after the child.
Well, there would be a strong argument. There would be a strong argument in those circumstances to say, well, that's not really a proper choice. It's not really a question of choice in that case.
Well, except if the question is whether whether the child has to leave in those circumstances, you say, well, no, you can perfectly well stay with the grandmother.
Well, that would be the argument, no doubt, for the Secretary of State in a case like that. But it would be open, my submission, to a tribunal to say, well, that's not really a choice. That's more like the Zambrano end of the spectrum, where nobody could sensibly say, look, there's always and you can always say in these cases, there's always care.
I can see. I mean, you may be saying, well, this is all a question for the tribunal, and we should just, in this case, we should have stuck with the tribunal's decision and leave it there, which would be good for the Shah family, but not so good for the Patel family.
Well, if I'll come on in due course to explain why we say that the tribunal didn't really apply the right approach in our case, in the Patel case. But what I'm seeking to do at the moment is to demonstrate how we get to Chavez-Vilchez itself, which does set out in a little more detail, albeit still perhaps leaving some questions, how it is that this ought to be dealt with. Can I go in those second? Unless your Ladyship has any other questions about O, can I go to Chavez-Vilchez itself, which is 5, or page 606.
Now, am I right in thinking that Chavez-Vilchez is a Grand Chamber decision?
Yes.
Looks like it.
I think you are.
Well, looking at the people involved, whereas O was not.
I think that's right, my lady. I'm sure as you asked me, I'm sure it is right. But we go back to O.
It doesn't necessarily make the difference that it does in Strasbourg, but nevertheless, it's always helpful to know.
Yes. Yes. Yes, so I was at tab 5, wasn't I, which is 606 in Chavez-Vilchez. And again, I can take that, and I'm sure your Ladyship will have looked at it more than once before, but we can take the facts briefly from the head note. 8 claimants here, all third country or non-EU nationals residing in the Netherlands without residence permits. In this case, their mothers, so the non-EU citizens are the mothers for whom they are, of children for whom they are the primary day-to-day carers. The children and the fathers are Dutch. All but one of the children never left the Netherlands and thus never exercised their European Union free movement rights. As we've seen from Zambrano, that doesn't in itself matter because it's based on the treaty right to move freely and reside in the territory of the Union. The mothers had all separated from the children's fathers, but the level of the father's financial support and the relationships between the fathers and the children varied from case to case. Mothers' applications to the Dutch authorities for social assistance and child benefit were rejected on the grounds that they lacked rights of residence. And the mothers challenged those decisions, contending they had a derived right of residence pursuant to Article 20, since otherwise their children would be deprived of the genuine enjoyment of the substance of their own rights under Article 20 to move and reside freely within the member states. And the Dutch authorities took the view that a child would only be deprived of the genuine enjoyment of the substance of his Article 20 rights if the Union citizen father were unable to care for the child, and unless the father was in prison, hospitalised or dead, placed the burden of proving that fact on the third country mother. And essentially the question for the Court of Justice was whether that was a compatible interpretation of the interpretation of the way it should be that was compatible with EU law. Melody, we can pick up how the court, the Grand Chamber, as you point out, dealt with it. If we go to 646, Para 59. The referring court seeks, in essence, to ascertain whether Article 20 must be interpreted as precluding a member state from refusing a right of residence in its territory to a parent, a third country national, who is responsible for the primary day-to-day care of a child who is a national of that member state, when it cannot be excluded that the other parent, who is also a national of that member state, might be able to take charge of the primary day-to-day care of the child. The referring court seeks to ascertain whether the fact that the child is not entirely dependent legally, financially or emotionally on the third country national is relevant to that issue. So here again that phrase, legally, financially or emotionally dependent, is that relevant to the issue that needs to be determined? And then there's the recitation of the settled case law, Zambrano, the O case. A fair point is made at 62. Of course, the treaty provisions don't confer any autonomous right on the third country nationals. That's why it's described as a derivative right. The purpose and justification of those derived rights are based on the fact that a refusal to allow them would be such as to interfere in particular with a union citizen's freedom of movement. That's a reference to two cases I haven't taken you to, but I think are available if anyone wants to refer to them. And they refer to those in the case law. 63, they talk about very specific situations in which, despite the fact that secondary law does not apply and there's been no use of the freedom of movement, a right of residence must nevertheless be granted to a third country national who is a family member of that union citizen, since the effectiveness of union citizenship would otherwise be undermined. If, as a consequence of refusal of such a right, that citizen would be obliged in practice, is how they put it there, to leave the territory of the European Union as a whole. And we then, if we can, skip over to 65. If, in this case, if it were to be established, that being a matter for the referring court, the refusal to allow residence to the third country nationals at issue would have the effect that the parties concerned would have to leave the territory of the European Union. The consequence might be a restriction on the rights conferred on their children by their status as union citizens, in particular the right of residence, since those children might be compelled to accompany their mothers and therefore to leave the territory of the European Union. In the event that their mothers were obliged to leave the territory, their children would thus be deprived of genuine enjoyment of the substance of their rights. And the court then sets out what the Dutch government had said, that the mere fact that the third country national parent undertakes the day-to-day care of the child and is the person on whom that child is in fact dependent does not permit, legally, financially or emotionally, even in part, not permit the automatic conclusion that a child who is a union citizen will be compelled to leave the territory of the union. And they say the presence in the territory of the member state of which that child is a national, or in the territory of the union as a whole of the other parent, who is himself a union citizen and is capable of caring for the child, is, according to the Netherlands government, a significant factor in that assessment. We'll come back to the fact, come to the facts of our case in a bit, but the analogue in the Patel case for the other parent or the other person or the grandmother, in my analogy, is of course the state provision, which it might be said could always be provided if your carer leaves. And there's then the Dutch government's position is set out at 67. There's a reference back to the O case. There's reference at 69 to the second factor, that's to say the question of whether the child is legally, financially or emotionally dependent on the third country national parent. The court has stated that it is the relationship of dependency between the union citizen who is a minor and the third country national who has refused a right of residence that is liable to jeopardize the effectiveness of union citizenship, since it is that dependency that would lead to the union citizen being obliged in practice to leave the EU. And then importantly, 70 onwards sets out how this needs to be done, how this exercise ought to be done in this case, in order to assess the risk that a particular child who is a union citizen might be compelled to leave the territory of the European Union, etc., 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 it is important to determine in each case which parent is the primary carer of the child and whether there is in fact a relationship of dependency between the child and the third country national parent. As part of that assessment, competent authorities must take account of the right to respect for family life, as stated in Article 7 of the Charter of Fundamental Rights of the European Union. That article requiring to be read in conjunction with the obligation to take into consideration the best interests of the child, recognised in Article 24(2) of the Charter. And for the purposes of that assessment, I'll come back in a minute to what the implications are of that reference to the Charter. For the purposes of such an assessment, the fact that the other parent, a Union citizen, is actually able and willing to assume sole responsibility for the primary day-to-day care of the child is a relevant factor, but is not in itself a sufficient ground for a conclusion that there is not, between the third country national parent and the child, such a relationship of dependency that the child would be compelled to leave the territory of the Union if a right of residence were refused. In reaching such a conclusion, account must be taken in the best interest of the child concerned of all the specific circumstances, including the age of the child's physical and emotional development, the extent of his emotional ties both to the Union citizen parent and to the third country national parent, and the risks which separation from the latter might entail for that child's equilibrium. So, my lady, in those circumstances, we submit that it's plain from this that a much broader inquiry necessarily requires to be undertaken than simply asking yourself, as a matter of fact, what would happen if the non-EU citizen were removed from the Union. And I said I'd come back to the reference to the Charter of Fundamental Rights. That's talking, of course, about the right to respect for family life, which is the analogue of Article 8.
Is that the correct antithesis? What the court was dealing with was the Dutch government's suggestion. You could effectively operate a tick box. Is there another parent? Is he alive? Well, is he in prison or in hospital, or for some mental reason incapable of care? And if all those got crosses, then there wasn't. Then in those circumstances, the Dutch government said that was the end of the case, and the court is saying, no, it's not. You've got to conduct a more nuanced assessment.
Well,
For
if that's
the
all,
purpose of deciding what I think you've earlier called what they call the obliged in practice to leave.
Yes. Well, if that had been all that the Court of Justice had said in Chavez Vilches, then that might have been right. But the Court didn't need to say what it did say. The Court could simply have said that. The Court could simply have said, well, the Dutch government adopts this tick box approach, and the real question is not a tick box approach. The real question is simply whether the EU citizen would be forced to leave the territory of the Union, and left it at that. But they don't do that. They go on to give some detailed guidance about the sort of factors that are important, and they emphasise the importance of looking closely at the question of dependency. And they talk about the need to take into account the right to respect for family life. Well, that reference in particular, the right to respect for family life, in my submission, can't make sense if one is simply looking narrowly and dryly at a factual inquiry. One doesn't answer as a judge a factual question by thinking about rights. One looks at the facts, even if it's a conjecture about what will happen, which is just as much a factual finding in a way as a finding about what did happen.
Well, can't one factor in a perception of their rights, including a right to family life and a perception of the children's best interests, into the thought process of the person who in practice is going to have to be taking the decision for the child, as part of the analysis which the court has to take to see whether it's a real choice or not?
I suppose that might be a way of putting it, but it is. I say it does come down ultimately to a question about whether taking account of the rights environment, as it were, in which this is happening, one can really properly talk about this being a choice. And that's not quite the same thing, perhaps, as saying looking at the thought processes of the person who will be making the decision, because one can envisage a class of case where the person who has to take the decision, who in this case is the parent who's deciding whether to take the child out of the union or not, could take either of two decisions without infringing the child's rights in any way. But nevertheless, the court says you've got to look in this context at the rights. And that we submit it only really makes sense in a context where there is a thorough and intense focus on the alternative, and the question is asked, well, what is the can it properly be said in those circumstances that the alternative is something between which the alternative is something which represents a real choice, or is it really not a matter of choice but of compulsion? And that's really the only way in our submission in which one can make sense of this. And
the gist of paragraph 71, so far as I can give sense to it, it seems to be if the children are very young, you really wouldn't expect them to be sort of stripped away from their mother, who is the primary carer. Therefore, that might be a situation where if the mother is removed, that will be a situation in which, in terms of the parlance of the European Court, there wouldn't really be a choice about the matter. The child would have to go.
It would be a matter of obligation, yeah.
Whereas, query 15, 16-year-old with very good relations with the father, that much more mature themselves, some realistic prospect that they will be looked after by the Dutch national if the mother leaves. Well, perhaps the table has flipped a little bit, and one wouldn't say then compulsion.
Well, possibly, my lord, yes, possibly that might be right. And then those, to put it the other way, one might say in a case like that, it might be said, well, it's not a matter of obligation; it will be a matter of choice to leave. But inherent in that is that one needs to undertake that exercise, and one can't simply content oneself as a tribunal with saying, well, I'm going to decide whether, as a matter of fact, the person would leave, without considering whether that which the person would be stuck with if they remained is something which is compatible with the values that one's seeking to give it, that one has to give effect to. That's the only way in which in our submission one can make sense of the reference to the Charter. Which otherwise
just
doesn't make
speaking
any
for myself,
sense.
one slight difficulty I have with the debate about is it a real choice, is it not a real choice, is that, in a sense, and this may help you, I hadn't really thought it through, that whether you count it as a choice for legal purposes, in a sense, always depends upon the parameters in which someone is operating. I think Thomas Hobbes gave the example of giving your wallet to a highwayman. He says, you most genuinely choose to give your money to the highwayman because he might shoot you otherwise. But
Yes.
the law wouldn't treat that as a voluntary transfer because the law says, well, you haven't been presented with proper, a choice within proper parameters. And I think that sort of supports you, at least to some extent, in that you're saying that the construction of the choice is within certain parameters, which has a normative content.
Yes.
Is that a fair way of putting it?
No, it is, yes.
Is it also a question of who is going to exercise the choice? That it can't be solely a matter for the parent?
Well, it will be. Well, it's complicated in the case of a child, of course, by the fact that the child, I mean, depending on the age of the child, can or can't make his or her own choice. So, in a young child, it will always be the parent's choice in the first instance, leaving aside cases where, for whatever reason, the court or the state, in some sense, is in charge as a prior state of affairs. It will always be the parent who makes the choice for the child, but it's nevertheless got to be the choice that one has in mind is conceptually must be, I suggest, the choice of the EU citizen who is being presented with the consequences of the departure of the non-EU citizen. That's why it is important to focus on it from the perspective of the EU citizen.
Sorry, I became a little bit lost. When you say the EU citizen, in the child cases, you're talking about the choice of the child?
Yes. I mean, it's the choice of the child. The child. Well, in that sense, the child's choice is exercised on its behalf, of course, by the parent.
So,
But that shouldn't confuse us into thinking that what we're concerned with here are the parents' rights. That's all I mean by that.
It's precisely at that point that the bearing in mind the child's best interests requirement focuses one on needing to treat that as a relevant parameter, if affecting whoever it is, and it may be one person or it may be two people doing it jointly, the decision.
Yes.
But ultimately, the court's got to be satisfied objectively about the question of choice, isn't it? The parent can't just say, I prefer the child to be here, and for the court have to.
No, preference by itself can't go. That would be directly. That would be that would be effectively the parent saying it's desirable.
well, that's why I put to you the point about what desirable means in Dept. It's desirable in a very strong sense, because ordinarily you wouldn't leave your 2-year-old child for the Dutch state or the Belgian state to look after it rather than taking it yourself. But that wouldn't be good enough, as I understand Dept, to amount to compulsion.
Well, Dept was not a Zambrano type case where it was a straightforward issue of two parents and two tiny children. And Dept was the case where it was the non-EU father, but with the Austrian wife with Austrian children.
Right.
So,
but suppose there are two-year-old children and the parents love each other and would like to bring up their children together. That's a very strong sense of thinking that's desirable. Most people would think that in a moral sense you're compelled to stay together, but that's not good enough for EU law.
Well, I agree. When the court says it's not enough merely to be desirable, I accept the logic of your lordship's point that it could be very desirable and still be not enough from the court's point of view. That I accept, but that by itself doesn't really diminish the force of our point. That one needs to address all of this and look specifically at how the dependency works on the facts. And I'll come on in a second, if I may, to look at how that works. But I want to make, if I may, a bit of progress. Very briefly, if one goes to volume 3, tab 48, we can see the response, just out of interest, of the Dutch government to the Chavez-Vilches case.
Do you have a page number?
I'm sorry, my lord. It's 1704.
Thank you.
That's the translation of what's on the previous page, but taking it very quickly because I'm conscious of the time and I need to leave some room for my friend Mr. Malik to say things on behalf of Mr. Shah at 12 o'clock. 1705, by this judgment, says the State's Secretary for Security and Justice, I am forced to adjust the policy. The ECJ sets the condition that even if the Dutch parent can and wants to look after the child, further investigation must be done into what can be summarised as the child's interest, whereby the burden of proof is shifted to the government more than before. Even if the Dutch parent is willing to take care of the child, it must be demonstrated that the divorce with the third country parent has no negative consequences for the child. Such an investigation is expected to lead more often to having to grant the right of residence to the third country parent. I merely flag that up to illustrate that the Dutch government perceived that there was a change in the approach that was necessary. The next case I wanted to go to is KA, which is at 730. That's behind tab 8 of the authorities. This is important because it shows that the Zambrano principle is not limited to the dependency of a minor child and can, in principle, apply to adults who are dependents as well. And we can see that if we go to 731, top of that page, who were the applicants? About an inch or so down the page, the applicants lodged in Belgium applications for residence permits based on family reunification, namely their status as, respectively, a dependent relative in the descending line of a Belgian citizen, the parent of a minor Belgian child, and a lawfully cohabiting partner in a stable relationship with a Belgian citizen. And if we go to, again, I apologise for skipping through it, but I need to make some progress. We go to 63, paragraph 63, which is at page 781. Under the heading, the existence of a relationship of dependency capable of justifying a derived right of residence under Article 20 in the main proceedings. The court says that it's necessary to investigate the circumstances, and it refers at 64 to the fact that some of these applicants are adults. And at 65 says, as regards first the cases in the main proceedings where the respective applicants are KA, MZ and BA, it must at the outset be emphasised that unlike minors and a fortiori minors who are young children, such as the Union citizens concerned in the case that gave rise to Ruiz Zambrano, an adult as a general rule is capable of living an independent existence apart from the members of his family. It follows that the identification of a relationship between two adult members of the same family as a relationship of dependency capable of giving rise to a derived right of residence under Article 20 is conceivable only in exceptional cases, where, having regard to all the relevant circumstances, there could be no form of separation of the individual concerned from the member of his family on whom he is dependent. And having said that, they fairly promptly say that nothing in the facts of those cases satisfactorily met that test. Well, my lady, we rely upon KA just to demonstrate what the logic of the principle anyway shows, which is that it can be applied to adults. The Secretary of State understandably places great emphasis on the fact that the court there talked about how this was conceivable only in exceptional cases. And of course we accept that if by that you mean that it's not the normal case and that you need to bring yourself within it. We don't accept it if it's intended to introduce some sort of separate test of exceptionality. And this is better covered perhaps in Liberty's written submissions, so I won't deal with it now. But the court is no doubt familiar with the perils of setting out or being thought to have set out a further layer of test along the lines of exceptionality, and that's not in our submission what the Court of Justice was seeking to do. They were merely pointing out that as a matter of fact, generally speaking, adults are not dependent on each other in the same way that children are. So that's all I really want to say about that case. The English cases I can deal with fairly rapidly, if I may. I wanted to take the court just to one passage in one of those cases. And that is the Court of Appeal in Harrison. That's behind tab 2 at page 538. And it's just a paragraph I wanted to show you, Ladyship, in the judgment of Lord Justice Elias at page 562. Paragraph 67, as to the submission that EU law might develop in that direction, which is to say a direction that our own friend Mr. Drabble had submitted it should develop in, which perhaps is more liable to result in a finding of infringement. I accept that it's a general principle of EU law that conduct which materially impedes the exercise of an EU right is in general forbidden by EU law, in precisely the same way as a deprivation of the right. In my judgment, it's necessary to focus on the nature of the right in issue and to decide what constitutes an impediment. The right of residence is a right to reside in the territory of the European Union, is not a right to any particular quality of life or to any particular standard of living. Accordingly, there is no impediment to exercising the right to reside if residence remains possible as a matter of substance, albeit that the quality of life is diminished. So far, so good for the Secretary of State's point of view. But then the court goes on, of course, to the extent that the quality or standard of life will be seriously impaired by excluding the non-EU national, that is likely in practice to infringe the right of residence itself, because it will effectively compel the EU citizen to give up residence and travel with the non-EU national. In such a case, the Zambrano doctrine would apply. The other case, I don't have anything at the moment further to add about that case. The other one I wanted to take the court to is a recent decision of the Court of Appeal, very recent decision, in MS Malaysia. And that is at paragraph 25, sorry, forgive me, tab 25, which is page 1112. It's in volume 2 of the authorities.
Sorry, could you give me the MS number again?
Yes, it's 1112.
Thank you.
Very recent decision, 9th of April this year. And it's about an adult primary carer of an EU citizen parent. So in that sense, it's like our case. The facts are set out in the judgment of Lord Justice Floyd, with whom the other members of the court simply agreed. Paragraph 6, page 1113. Taking it again fairly briefly, we can see that that DK, who is the EU national, has restricted mobility, uses a walking stick and Zimmer frame, short-term memory loss, 9 different drugs, deteriorating eyesight and so on, needs all sorts of help. And there's the question of alternative arrangements being made. The conclusion is drawn by the FTT there that residential care would not be an adequate alternative arrangement. That's paragraph 9. There's then a discussion about the law that I'm not going to take the court through because it essentially summarises law we've already been looking at. We come on to the discussion of the grounds of the appeal. There's reference there to the usual principles about caution in disturbing findings of fact. What I wanted to pick up in particular, though, was paragraph 37, where counsel had submitted that the judge had wrongly addressed the question whether DK would feel compelled to leave. And it was said the substituted a subjective analysis for that required by the regulations, which required actual compulsion assessed objectively. And the court says that viewed in isolation, paragraph 38, that has superficial attraction. 39, the judge did not, however, suspend further consideration of the appeal at the point where he concluded that he accepted DK's evidence. DK had said that she would leave. Nor did he expressly say that he was treating DK's evidence as conclusive as opposed to giving it weight. He went on to explain why, by reference back to all of the evidence given before him, including that of MS, and the preserved findings of fact from the decision of the FTT, he considered that DK would inevitably be compelled to leave with MS. Whatever the advantages to some might be of remaining in the United Kingdom, what was paramount for DK, and what deprived her of an effective choice, was her need to remain with her daughter. And that was described as a perfectly proper global objective assessment, taking account of the evidence of MS and DK, that's to say the EU national and the non-EU national, and all the other surrounding circumstances. The facts are then set out: 24-hour care, needs as an Orthodox Sikh, residential care being inadequate. It was these considerations, having seen and heard the oral evidence of DK and MS, which had led the FTT judge to find that DK's quality and standard of life would be, as Lord Justice Elias put it in Harrison, seriously impaired. That was the passage we looked at. The judge who saw and heard the witnesses applied the correct test and arrived at a conclusion that was open to him. And there's also criticism about alleged failure to factor in the availability of state medical and social care. That's said to be not a fair criticism because the judge made frequent reference to it, paragraph 41. 42, the availability of state-funded medical and social care will in many cases make it hard for those who provide care for their elderly relatives to bring themselves within the regulation, but it is not to be treated as a trump card in every case, irrespective of the nature and quality of the dependency on the carer which is relied on.
Well, why are they talking about the availability of state-funded social care?
Because it is said by the Secretary of State raising that appeal that the judge didn't adequately take into account the fact
really
that there was
making
no
the point
real...
that social care is not state-funded in the same way that medical care is.
Oh, I see what you mean. Yes, I hadn't been alive to that distinction, but now you mention it, I see what you mean. Yes, it's not an accurate...
Well,
it's not an
It
entirely
is
accurate...
partially state-funded, but not in the same way that medical.
No, you're well quite. It's a matter of some political controversy that it's not, and how it ought to be if it is going to be. I agree. But the point there for our present purposes is that doesn't even if state care, even if there is such a thing as state-funded social care, it doesn't avoid the need to inquire into the actual dependency. It's a relevant but not decisive factor.
A lot of weight is put there on the sort of test of seriously impaired, which is taken from Harrison.
Yes.
Does one find that in the EU ECJ judgments as such? I don't think it does.
No, I don't think one does.
Lord Justice Elias's interpretation.
Yes, I think that's his interpretation, my lord. But can I then turn to the facts of our case? And, well, I'm sure that the court will have read those with the usual care. I nevertheless want to draw your attention in particular to a few passages in some of the evidence. Can we start in the occupational therapy report, which we can find at page 392. This is at the appendix part of the back, so in other words, the back, tab 10, the back of the 4 volumes. It's described on its face as a draft report, but none of us can work out why that is, but I think we can take it, it's common ground. This is the report that was put before the first-tier tribunal. And picking it up, if I may, at 394, there is a summary. It was based on a 3-hour assessment. Bottom of that page, in the middle of 1.3, the summary and conclusion of this assessment is that Neelay Patel, that's our client, is providing a very high quality of care 24 hours a day, every day of the year, using specialised skills for the care of his father and providing both parents with practical and emotional support that, in my opinion, based on my professional experience working in the community, could not be provided through statutory services. So there's clear evidence there that what Mr. Patel Jr. is doing is irreplaceable. And if Mr. and Mrs. Patel no longer have the support of their son as they do at present, and he returns to India, and in brackets implicitly, and if they were not to go, Mr. Patel Sr. would require a residential nursing home placement or 24-hour specially trained live-in care with a team of carers. And a little of the flavour of quite how extraordinary in our submission the extent of the dependency is in this case. We say it wasn't sufficiently recognised by the courts below and not properly dealt with. We can pick up from 402 if one looks at the daily routines. And perhaps I can just invite the court briefly to read through from 402 to, or either to read through now, perhaps to Mark to read up later if there's time, 402 to 405. Well, probably on reflection, that's a bit of a long passage to ask you to sit there reading while I wait. But I emphasise, but I would ask the court to read it in due course, but I emphasise from this the sheer intensity of the work that is done by Mr. Patel. In this context, he has to wash his hands for 2 minutes and use an alcohol sanitizer before touching lines and catheter, records the report of the night, results of therapy, fluid output, body weight, blood pressure taken, liquid from dialysis carried downstairs, emptied out, bath cleaned, None of this apparently can be done by social services. That takes an hour for a manual exchange, an hour to dispose of, hour to set up, hour for exchange, hour to dispose of waste fluid. Assistance with showering is then needed. Mrs. Patel can't do any of this because of her own difficulties. She has to go shopping with her son. Nilay Patel gets the rest of the morning to himself, what's left of it. Sorts out all the rubbish, of which they have a lot because of all the stuff that you need to get through for the dialysis. And then 5:30, he takes them all to the temple. 6:30, the dialysis machine set up again, bottom of 403, 30 to 35 minutes. Evening meal, an hour and a half of warming them the liquid up. Dinner. Then Mr. Patel takes over as effectively a nurse again, weighing his father, goes upstairs, blood pressure test, dialysis for 10 minutes, machine cycling, attaching the line, and sometimes once or twice a week during the night, attention is required to check the machine, or if Mr. Patel Senior needs to go downstairs to use the lavatory, and sometimes the machine bleeps. And then during the night at the bottom of the page, Mr. Patel usually sleeps through. Where does he sleep? In case one hasn't already picked this up, he sleeps on a roll-up bed at the foot of his parents' bed in their bedroom so that he can give immediate attention where necessary. And the other thing which does not emerge from that picture of a typical day is that that's a day when there's no need to change the dressing. Every other day the dressing needs to be changed as well, so you've got that to add to as well. So it is...
what Mr. Patel Jr. does is deeply impressive, we can see. But is it really the case that Mr. Patel Sr. would leave to go to India himself if Mr. Patel Jr. was removed to India? What's the evidence for that?
That was the inference that the court was, that the tribunal was invited to draw from all of the circumstances. I'll come on in a second to look at how it was done in the first tier tribunal. But yes, that is the... I accept that.
Is there any evidence to support that inference?
There is not the equivalent that we saw in the MS case of a direct statement from the equivalent person, I will leave if. But that may be because of difficulties that Mr. Patel Senior has with expressing himself. We don't know, but there isn't that direct evidence. I accept, but it's an inference that the tribunal was invited to draw, and I'll come on in the last part of my submissions just to look at how that was dealt with, and why we say essentially, and this is to cut to the point. I'll come to it properly in a moment, but why we say essentially that if the tribunal had, as we contended ought to have done, conducted the fuller analysis which the cases and the principles underlying the cases compel, then it might, and this court we submit can't be sure that it wouldn't have concluded that actually Mr. Patel Senior would be deprived of the rights of the benefits of his EU citizenship. He would, in other words, be forced to leave. But can I just, before I get there, just complete what I wanted to say about the evidence? If we skip to 408 in the occupational therapy report, it's absolutely essential, bottom of that page. It is said that the very highest standards of cleanliness and infection control are maintained. Extremely difficult to ensure this with the rota of outside carers. Then in the middle of the next page, 409, psychologically and emotionally, Mr. and Mrs. Patel would not be able to cope with strangers caring for them. Culturally, this is very difficult, and in any case, to date, their son has provided for their care. Mrs. Patel becomes distressed and tearful with the prospect of not having her son living with them, and Nilay has said that if he is unable to stay in this country, he will take his parents back to India to care for them, even though his father will be unable to continue with his present treatment of peritoneal dialysis. That's one of the forms of dialysis, as the equipment and consumables are not available in India. In summary, a very high level of care is being provided. I also wanted to take the court briefly to the psychological report. That's behind tab 10, it's page 382. least that's the passage I wanted to go to. It starts, if you want to see the start of it, at page 374.
Sorry, page?
Page 382, my lord.
Thank you.
Where I'm going to. Paragraph 58, removing Nile from the UK will have a significant detrimental effect on his parents' physical, mental and emotional well-being. Parents are highly dependent on him for emotional, practical and social support. Highly dependent, I emphasise that. And removing this is likely to trigger a significant deterioration in Mrs. Patel's mental state. This will have a consequent negative impact on Mr. Patel and the family system as a whole. This is all of course, written on the, we would say, as it were, counterfactual premise that Mr. Patel Jr. were to leave and they were not to follow him. Mr. and Mrs. Patel are highly likely to become socially isolated. They will not be physically or mentally strong enough to carry out their activities of daily living. Mrs. Patel is not able to leave the house without her son. She feels scared and worried about the future, and as a result, she's been experiencing episodes of anxiety, as evidenced in the nightmares, increased heart rate, sweating, and poor sleep and appetite. Miss Nile feels helpless from a cultural perspective. Son's duty to look after and support his parents. 61, removing him would have a significantly detrimental effect on his parents' physical health and emotional well-being.
Just before you get to 61.
Yes.
In the middle of 60, he would not be able to get a job in India or be in a position to support his parents. Does that mean in India? I think it does.
It's not entirely clear what...
No, but I'm looking for evidence that in practice, that the parents really could go to India with him, bearing in mind his father's very serious condition.
Yes, well, there is. I think it's right to say. I'm sure my friend will correct me if I'm wrong. I don't think that there is anywhere in evidence. I have to accept any evidence that directly speaks to what could be laid on in India in order to cater for the parents, were the parents to go with Mr. Patel Jr.
One wonders how it would be practicable for the father even to get to India if he needs 8 hours dialysis.
Well, there's no direct evidence on the point, but there's certainly nothing in the evidence to say that there's a physical bar to them getting to India. I was going to just look briefly, and I'm conscious of the time, but if my friend will forgive me while I take a couple of moments to do so, look briefly at how the First-Tier Tribunal then dealt with it. First-Tier Tribunal Judge Miles, whose judgment we can see at 297. And the judge looks in some detail at, the judge mentions that paragraph 11, I should say, first of all, the appellant's oral evidence, Mr. Patel's oral evidence, together with that of his father and mother, which I've noted above, relies on the documentary evidence provided both at the time of the application and for the purposes of the appeal, and I can confirm that I have taken account of all of that information. So in that sense, there is a general statement that everything's been taken into account. What is perhaps a bit striking is that there is hardly any reference to any of the specifics of either of the two reports that I've just taken the court to. I'll come back in a second to the one brief reference that there is, or apparent reference. Paragraph 12 sets out some of the evidence about how the appellant looks after Mr. Patel, which must of course come from the Downing report. But at this point, there were, of course, two issues, and this is perhaps not immediately apparent, but there are two. One issue is whether, in fact, and I haven't taken you to it, but whether the regulations that give effect to all of this in England were satisfied to the extent that Mr. Patel Jr. had persuaded the tribunal that he was the primary carer. And that conclusion, the court's conclusion on that question, the tribunal's conclusion on that question appears at paragraph 14. The answer is yes. And therefore, the area of dispute, says the tribunal at the end of paragraph 14, is whether the appellant has also established the requisite standard that the relevant British citizen, i.e. his father, would be unable to reside in the UK or another EEA state if the appellant were required to leave. But what's significant about that is that it seems that at that point, the material that we've just looked at is rather put to one side. Certainly it isn't referred to again. So it's used in the context of, is he the primary carer? Answer, yes. At that point, it's not further referred to. And then the factual findings are set out. 17, the appellant's argument is set out there that his father would have no option but to leave the UK. And the judge says the appellant's evidence is that the family has no family home in India, which is right, which is the country where the appellant would have to go to if he left the UK, nor does he have any siblings or any other family members in India able to offer accommodation and support. It seems to be derived from that. We can see further down that effectively they would be homeless in India, and that's a finding which is to some extent criticised later on, rightly in our submission, by the Court of Appeal. And there's reference to social services not having provided a timely service. And then at 19 you see the reference to the appellant saying his father would feel compelled to join him. The evidence must show that his father would choose to return to the country where he and his son would be homeless and without family support, which, as I say, is a considerable overstatement of the evidence. There is a fair point made next that there's no evidence of the medical care that would be made available in India. And then reference is made to the social services package that would be provided. Might well result in the appellant's father having to be admitted to hospital for dialysis treatment, which would clearly not be as good as the current arrangement.
Can I just ask, was an Article 8 claim brought? I mean, it's not dealt with here, I think, but...
There was one brought in 2014 and then it was rejected.
Right.
Yeah, well,
the reason for asking is, a lot of the things you've shown us would seem to be, well, on the face of it, quite strong support for an Article 8 claim in conventional way, rather than trying to make the claim for a Zambrano type derived right. But anyway, it was looked
yes,
at.
Well, that
is what happened.
That hasn't gone unnoticed by me either. But yes, but nevertheless.
All right. Yes, thank you.
Yes. Anyhow, the conclusion that the first-tier tribunal judge draws, you can see halfway down 19. In those circumstances, the comparison between the situation of the appellant's father if he went to India with the appellant, as opposed to remaining in the UK with his wife but without the appellant, can only be resolved, in my judgment, by concluding that the notion of the appellant's father choosing or feeling obliged to leave the UK is simply untenable, despite the detrimental impact on both his parents, which I accept if he were to be required to leave. Simply unable to see, to accept that the father and mother would not see the reality of the situation, which the judge has said is that the medical needs can only be secured with any confidence by remaining in the UK. In those circumstances, the tribunal says that the claim isn't made out. The upper tribunal.
Now, how much time are you going to allow Mr. Malik?
I'm conscious I'm treading on his toes already, so I was going to finish in the next couple of minutes, if I may, if that's not going to discomfort him too much.
But, I mean, what is the error of law in paragraph 19? I mean, he's looking at all the evidence and drawing a conclusion.
My Lord, to come straight to it, the error of law is that the court does not conduct, we submit, the focused look at the dependency, bearing in mind all of the factors that are referred to in Chavez Vilches as applied by analogy to the case of an adult, which it ought to have conducted. Had it done that, then in our submission, the court the tribunal might have come to the conclusion, and on a remission, a fresh tribunal might come to the conclusion that this is a case where it is really proper to speak of Mr. Patel Jr.'s removal from the EU as amounting to something which compelled the departure of Mr. Patel Sr. and Mrs. Patel. Can I look just briefly, take your ladyship briefly, and this will be the last thing I want to deal with, to what the Court of Appeal said about this. And I can pick it straight up from paragraph 80 at page 277. Actually, I'm sorry, just before I go there, one page, 295, one line in the UT decision. Forgive me, my lady, I skipped over one thing. The upper tribunal rejected the appeal, as we know, on the grounds that the findings were open to the judge on the evidence. But importantly, it did say at paragraph 35, last sentence, the fact that the appellant states that he will take his father with him is not the issue. That is a matter of his or family choice, not of compulsion. It looks there as if the upper tribunal was essentially saying it didn't really matter because in any event this would be a question of choice, not compulsion. That's rather a precursor to what I've just taken you to, which is 277, what the Court of Appeal says. And at 81, at the end of 81, the Court says the question remains compulsion. At 82, the Court of Appeal doesn't appear to be ruling out altogether that the force of our submission that there should have been a broader inquiry, but they say it further seems, the judge says, it further seems, Justice Irwin says, it further seems to me that the evidence in this case was too equivocal to amount to compulsion, however one looked at the matter. No doubt as to the parent's devotion. Were he to leave to India, the son that is, there was no doubt the parents said they would follow, despite the findings below, but that really represented their cultural and individual commitment to each other. That, again, is choice, not compulsion. And in our respectful submission, that is simply too narrow an approach to the question, simply to brush this aside as a question of choice rather than compulsion doesn't, in our submission, give full effect to the jurisprudence. The Court goes on to say it was and is a difficult choice. And says that the upper tribunal judge, I think that should be a reference to Judge Mills in the first tribunal, considered on the evidence he heard that it was inevitable that the parents would in fact remain. Even if that were wrong, again admitting of the possibility that might have been wrong, this situation can in no way be regarded as one of compulsion to leave. There's an interesting discussion about the possible areas that might be regarded as compulsion in an adult case. The MS case shows us that it certainly isn't limited to those extreme cases. And finally, at 86, the Court, dealing with our factual appeal at that stage, says that the conclusion of, again, it's an error, it should be FTT Judge Mills, that the appellant's parents would remain may have been somewhat over-definite. Well, indeed, it was undoubtedly so in our submission. May have underestimated their strength of feeling about being cared for by their son, as opposed to being cared for by people who are as yet strangers to them. And I would add they wouldn't just be as yet strangers. In the nature of these things, they continue to be strangers because they're unlikely to be the same people constantly. If there was an error, it was not material to his conclusions in the case. At the very least, the case represented a very difficult choice for the appellant's parents. They were not obliged to leave in any sense. Hence, I would dismiss the appeal. And lady, our short point in conclusion is we do respectfully submit that if a fuller analysis had been undertaken by the first-tier tribunal, looking closely at the dependency and at the alternative to the current regime, and at the respects in which that alternative was completely unacceptable to Mr. and Mrs. Patel Sr., then it might have been, and one certainly can't rule out the possibility that it would have been, much more receptive to the notion that on the facts, that the test was made out, and that this was a case where one could not really say other than they would be obliged to leave. Those essentially are our submissions.
Miladies, my lord,
I'm sure Mr. Drabble will take a blue pencil to some of his submissions if you go on a little bit longer.
I'm grateful. So I respectfully adopt the submissions made by my learned friend, Mr. O, QC, as to the principle and effect of Chavez-Wilches. And for those submissions, I too submit that the decision made by the court below is wrong. Given that I have very limited time for my submissions, and given that the court will hear submissions from Mr. Drabble QC shortly, I propose to make 2 short points as to the law, and will then make very brief submissions as to the facts of my case. My first point concerns what the court below said at paragraph 77 of its judgment as to the correct approach in cases involving children. Paragraph 77 is at MS page 276. This is page 26 of the appendix. And you will see that at line 4, in the third sentence, the court identified what it considered to be the correct approach, namely, if the non-EU citizen parent leaves, the British citizen will be unable to care for the child or children, ... The focus of the court plainly was on the inability of the British citizen parent to care for the child. Unable to care are the words used. The court applied that test at paragraph 79. And if one looks at the second line of paragraph 79, applying the test set out at paragraph 77, the court concludes that if the appellant leaves the United Kingdom, the British parent would be capable of looking after the child. Well, I respectfully invite the court to consider and compare this formulation with the formulation set out in Chavez-Wilches at paragraphs 71 and 72. Paragraph 71 is at page MS 648, tab 5 of the authorities volume. You'll see that the words actually able and willing are used in the second line. And the same words are repeated at paragraph 72, which is on the next page, just above letter B. So the focus here in my respectful submission is not merely on the inability of the British citizen parent to provide care, but also on the willingness of the British citizen parent. The court below, in my respectful submission, misstated the test. The court treated the British citizen parent being able to provide care as determinative, and for that reason, in my submission, erred in law. If, in my respectful submission, a British citizen parent gives evidence that he or she is simply unwilling to assume sole responsibility for the child in the United Kingdom, and if that evidence is accepted by the fact-finding tribunal as credible, that would mean that the test in paragraph 72 of Chavez-Wilches is satisfied. If the fact-finding tribunal finds that the British citizen parent, contrary to his or her evidence, is actually willing to provide care for the child in the United Kingdom. Subject to other arguments, the appeal may fail. But the position would be different, where in my respectful submission, there is a sustainable factual finding as to the unwillingness of the British citizen parent to become the sole carer in the United Kingdom. My second point concerns how the court below approached the issue concerning the welfare of the child involved. The only paragraph in the Court of Appeal's judgment that relates to this issue, perhaps indirectly, is paragraph 78. It is at MS page 276, page 26 of the appendix. In my respectful submission, it is rather striking that the paragraph starts with the words I would wish to emphasize that ... It appears in my respectful submission to be an afterthought, and it is said in the first sentence and in the second sentence that even in cases involving children, the right to respect for family life is merely a relevant factor and is not a trump card. There is, in my respectful submission, a complete omission to recognize the obligation to take account of the best interests of the child as a primary consideration in Article 24 of the Charter. Of course, it's not a trump card, but in my respectful submission, it's also not merely a relevant consideration. It is a primary consideration. The effect of paragraph 72 of Shah's Wilches, which the court has seen, in my respectful submission, is that an assessment as to whether the child would be compelled to leave the United Kingdom must involve assessment of all relevant factors, including the age of the child's health, emotional development, and the extent of the emotional ties with the British citizen parent and the third country national parent, and also the risk arising from separation. If, in my respectful submission, after considering all these factors, the fact-finding tribunal takes the view that there is no real option for the child to remain in the United Kingdom, then in my respectful submission, the test in Shah's Wilches would be met. If a child is 2 years old, as Lord Sales observed, one would not really expect that child to leave the third country national mother to live with the EU citizen father in the United Kingdom. The position might be different if the child is, say, 16 years old and has developed a relationship with the EU citizen father, and remaining in the United Kingdom would not undermine his physical and emotional development. The risk to the physical and emotional development of a 2 years old child arising from separation from his mother is obviously different from such risks to a 17-year-old child. In my respectful submission, the hard-edged approach adopted by the court below is wrong for that reason. In my submission, it also fails to take account of the substantive body of authority on separation of child from parent in Article 24 of the Charter. You have a summary of the relevant jurisprudence at paragraphs 3.2 to 3.25 of Liberty's written case, and you'll hear further on this point from Mr. Trouble, QC in due course. Now, may I now turn to the facts of my case, and may I respectfully take the court to the decision made by the first-year tribunal. It starts from MS page 429 It's page 179 of the appendix.
One,
Page 179 of the appendix, page 429, MS, page number 429. Now you'll see that the Secretary of State was represented at that hearing by a presenting officer. The appellant and his wife gave evidence, and both were cross-examined. If you look at paragraph 6 of the first-year tribunal's decision, this is at page MS 431, you will see that it refers to the evidence given by the appellant under cross-examination. Now, it is plain that the appellant has the responsibility for the day-to-day care of the child, and his role in the child's life is vital and primary. Paragraphs 7 and 8 set out the evidence given by the mother under cross-examination. Her evidence was that she, I quote, cannot assume full responsibility, and they will have to move as a family. There is a reference to work commitments in that paragraph, but it appears that that point was not probed further in cross-examination. It appears that it wasn't put to the mother as to whether she was willing to give up or alter her work commitments in order to care for the child. Now, this is the context in which the tribunal made its findings. The findings are set out at paragraphs 11 to 18. And if you look at paragraph 15, you'll see that it contains the findings as to the role that the appellant plays in the life of the child. And if you look at the middle of that paragraph, you'll see that the appellant would prepare child's meal, would give him bath, would carry out general cleaning around the house, would take the child to doctor's appointment, and would spend time generally with the child. Paragraph 17 is the paragraph where the tribunal made a factual finding that if the appellant was not permitted to remain in the United Kingdom, the British citizen child would have to leave the country. The reason being that the mother had said that she would move as a family, and she cannot assume responsibility for the child. The tribunal accepted that evidence in clear terms in the final sentence of paragraph 17. Paragraph 18 is the overall conclusion. You'll see that in that paragraph, the tribunal takes into account the best interest of the child and the need for the child to remain with both parents. And that, in my respectful submission, also takes account of the age of the child at that time. And the conclusion that the first-year tribunal reached was an obvious one, that if the father is required to leave the United Kingdom, given the role that he plays in the child's life, the child would have to leave with him. The upper tribunal's decision starts from page MS 423. If you look at paragraph 4 of that decision, you will see that the Secretary of State made an argument that the first-year tribunal gave no consideration to the mother reducing her work hours to take care of the child. Now, this submission was made despite the fact that the mother was not challenged in cross-examination on that particular point. The answer given by her that she cannot assume sole responsibility of the child was not probed further. The upper tribunal made that point at paragraph 9 of its decision, which is on the next page, page 175. And if you look at the middle of that particular paragraph, you'll see that the upper tribunal noted that the evidence given by the two witnesses was found to be credible by the first-year tribunal. And there was no evidence before the first-year tribunal that the child could be taken care by anyone other than the parents, and primarily by the appellant. The Secretary of State was represented at the hearing before the first-year tribunal, had the opportunity to probe the two witnesses, but that wasn't done, and the upper tribunal, in my respectful submission, correctly concluded that in absence of further probing on that point or any evidence, the first-year tribunal could not have speculated as to the alternative arrangements. The Court of Appeal interfered with the decisions made by the specialist tribunals simply on the basis that the mother was able to provide care for the child without the appellant. See paragraphs 77 and 79 of the Court of Appeal's judgment. That, in my respectful submission, was not a principled basis to set aside the decisions made below. The tribunals, in my submission, were entitled to find that there was no real choice apart from child leaving the United Kingdom. And in any event, one has to have regard to the fact that the child here has no choice in any real sense. Now, for these reasons, I respectfully invite the court to allow the appeal and restore the decisions made by the first-year tribunal and the upper tribunal. Now, alternatively, if the court takes the view that the questions as to the mother's choice, if any, work arrangement and welfare of the child require further probing, then the matter in my submission should be remitted to the first-year tribunal. In my submission, it was not open to the Court of Appeal to conclude that the outcome was inevitable, and no matter how one looked at this case, the test was not met. Lord Sales asked a question when my learned friend was making his submissions as to whether Article 8 was raised in Mr. Patel's appeal, and that question perhaps would also arise in Mr. Shah's appeal. The answer is this, that the relevant statutory framework does not permit an appellant to rely on Article 8 in an appeal against a refusal of an application for a residence card.
No, it's a different claim. In fact, in paragraph 79, the Court of Appeal say, in Shah, a claim under Article 8 has already been rejected.
Well, yes.
But I think the position, it sounds as though it's the same as in the Patel case. Separate Article 8 claim, but rejected.
Yes, so there, even before the child was born, Mr. Shah made a human rights claim to the Secretary of State. That claim was rejected, and there was no challenge to that rejection. Mr. Shah then made his application for a residence card. That application was refused, and that refusal triggered the instant appeal. And in this appeal, it wasn't an option for Mr. Shah to rely on Article 8. The authority, if needed, is the judgment, and is the judgment of the Court of Appeal in Amir Tamur. It's the judgment of Lord Sales. The citation is 2017 EWCA Civ 353. So unless I can assist any further, these are my brief submissions.
Thank you very much indeed. You've done very well to keep within the less time than you'd indented for.
you.
Yes, Mr. Shah. Yes.
My ladies, my lords, the Air Centre is grateful for the chance to make these brief submissions. We support the approach of the appellants. In particular, we submit that the test applied by the Court of Appeal in these cases to what it saw as a distinction between choice and compulsion was too narrow. We submit that following the decision of, in fact, the Grand Chamber in Chavez-Vilches, the factors that the domestic courts should look at can now be clearly identified. The conjuring trick, which is necessary to pull off, is what you do with the answer to the factors that have been spelt out. And my submissions are an attempt to try to provide an answer to that as best I can. We say that you can spell out of the condensed reasoning of the two critical paragraphs of Chavez-Vilches a number of clear building blocks posing issues which the domestic court must answer as it approaches the question and suggesting what the practical result of the conclusion is. So I want to turn to those building blocks in just a moment. We promised on our application for permission to intervene to say something about the decision of the Court of Appeal in Harrison. And can I just repeat what we said there? Harrison was a case consciously at the outer extreme of EU law. It was a case where the argument was not that the EU child or children would be required to leave the EU if the parent of the father was removed, Mr. Harrison, but that his quality of life, their quality of life would be interfered with. So in my respectful submission, it doesn't take you any further than, unsurprisingly, the Luxembourg authorities that it built on at the time and which can now be further built on. That position is actually crystal clear from the opening words of paragraph 56 of Lord Justice Elias's judgment, MS 560. That paragraph does refer to Article 24(2) of the Charter, which refers, of course, to the best interests of the children, but there was no possible case on the facts of Harrison that a best interest of an analysis would have produced a situation in which the court had to regard the child as being forced to leave the union. We just weren't in that territory. So, can I now turn to the building blocks as best I can? The first of them is slightly discordant with some of the submissions or some of the arguments and observations that have flowed between the court and my learned friends this morning. It is that the Luxembourg court, as opposed to the Advocate General in one situation, has not talked about the situation as one of choice. What they have talked about is a spectrum of matters which can be discerned from authorities such as Dept. I'll come to that in just a moment. Accordingly, what one is doing is not looking at whether or not the child, which is where my submissions are going to be fundamentally aimed, is exercising a choice, because as the domestic authorities recognise, that's a rather artificial concept. One is looking at the matter from the question of view of assessing the matter in the light of paragraph 70 and 71 of Chavez-Vilches, coming to an answer on what those considerations produce, and then deciding whether or not the situation is one in which the child is to be regarded as being forced to leave the EU. So we start from the position that we're dealing with a range falling between two extremes. If your lordships and my lady and my lordships will look at Dept just for a moment. It may even not be necessary to turn it up. It's at paragraph 68 at MS 687, tab 6. '68 says the mere fact that it might appear desirable to a national of a member state for economic reasons or to keep the family together is not sufficient in itself to support the view that the Union citizen will be forced to leave the Union territory if such his right is not granted. So the range is entirely within that very short paragraph. There's a mere fact that it might appear desirable to a national of a member state for economic reasons or in order to keep his family together, for members of the family to do not have nationality to be able to reside with him. That's one end, mere fact. My submission is that the language that's actually used in paragraph 68 is important. The word mere is therefore a reason. It's stressing that we are dealing with one end of the spectrum. At the other end of the spectrum is a situation in which the Union citizen will be forced to leave Union territory without the grant of the right of residence. Now that formulation...
Can I just ask you something on Dorici?
Yes.
It appears in some of the other cases. Paragraph 67, it says that criterion is specific in character. That rather gave me the impression that the CJAU was intending to be fairly directive as to what should happen in different cases. But can you help us as to what that is?
Sorry,
I'm so sorry.
I'm getting myself back.
67.
Well, all the case law is self-consciously aimed at a situation in which the remainder of EU law is not producing an answer to whether or not there's a right of residence. So it is as a targeted test. That's the thrust of your lordship's question. I would accept that. It's you're asking yourself whether this is a situation in which the domestic court should hold that the third country national, the non-EU citizen, has a right of residence.
But that takes you back to 66, which is talking about denial. The phrase my lord has picked out is emphasising the absence of choice.
Yes, I don't... It's like kind of, I say, peeling an onion. One goes down the layers and you just come up with what is meant by denial of the rights in these circumstances. Yes. Now, the answer I urge the court to give is that you apply paragraphs 70 and 71 of Chavez-Vilches in the way in which that court says it should be applied, and in the light of the principles that are relevant, in particular in the Shah case, to the best interests of children. That's going to give you the answer to the question of whether you should regard the EU citizen as being denied the right of residence. At 68, the formula in 68 is a very familiar formula to those of us who spent some time with Zambrano. It's repeated time and time again by the court. And in my submission, there's no need to look for choice or anything else. One simply says, well, we bear in mind that the mere fact that it might appear desirable, etc., is not enough. What you're looking for is whether the court forms the view that the Union citizen will be forced to leave the Union territory. That's the target.
But isn't choice just the other side of the coin of whether you're forced or not?
Well, but choice, the only reason for the caveat about choice is if you are looking for a child, the child doesn't exercise any choice at all, as the court has debated this morning. The parents exercise the child. The submission we make in the application for permission to intervene is that if the natural consequence of the denial of the right of residence to the third country national is that the child will leave, It's not helpful to talk about whether the child exercised a choice. You simply look at whether or not that departure is the natural consequence of a situation where the best interests of the children, viewed objectively, child rather, produce that answer.
I'm not sure that I follow that in the light of Derici. I would have thought in Derici it was pretty clear it was in the best interest of the child to remain with its parents.
Well,
And the parents were having to leave, therefore the child was forced on that argument.
Yeah. We need to kind of go through the criteria. The test as is actually applied by Chavez-Vilches, which of course postdates Derici. You won't find any further examination in Derici itself of best interests or any of these considerations. It just doesn't happen. It's putting down a marker that Zambrano itself is not to be extended. Whatever be the law, as it stood at the time of Derici at O, we now apply Chavez-Vilches. We now apply paragraphs 70 and 71. We go through the exercise and come up with the answer. Now, can I do that?
Sorry, just so that I can follow what you're saying about Derici 68, is your submission that that is without prejudice to the best interest of the child, which is now the governing, in effect, the governing criterion for these cases?
My submission is that the formula in paragraph 68 is the formula the CJEU repeatedly uses. It's now to be applied in a situation where we know from Chavez-Vilches the factors that need to be considered in order to answer the formula that's in paragraph 68. Derici doesn't itself give you any assistance with deciding how to answer the question. Chavez-Vilches does. And,
So I'm sorry that I'm struggling with this, but so we leave out of account a view that usually it's in the best interest of the child to be with its parents when we read Derici.
It's inevitably a question of degree, and we will see that there's quite a lot of background material in the form of the UNCRC and the Charter, which tells you the matters that feed into the issue of degree.
Yes, thank you.
And so I'll come to the way I say the test should be applied in a moment, which, and there's going to be an issue of a consideration of degree out there. My own friends have been canvassing the range of possible situations you may have with children. You may have a teenage child whose best interest may conceivably be to go with mother, but it can't be said to be seriously against his best interest to stay in the UK. You will have a different extreme where the child will, as a natural consequence, the young baby in arms or whatever, will go. We know it will go, and the answer to the Court of Appeal that's acceptable because a choice is being exercised is not an acceptable answer in the light of paragraph 70 and 71 of Chavez.
So again, is this right? You're saying that if in Derici it was a baby in arms, a 2-year-old or something like that, the answer would now be different. Would now be different because of Chavez. That's what you're saying.
That's quite an important caveat. It's we do now have to give the answer that the Grand Chamber in Chavez-Vilches has told us to give, both as to the route of assessment and the practical answer that is produced as a result of that.
Yes, thank you.
Now, Derici, I'm not going to answer the question about how far the thinking of the court had got in Derici. We know that the paragraphs immediately below the heading the right to respect for private and family life, including paragraph 72, have caused a huge amount of head scratching as to what precisely they do mean, as we canvassed in HC. But that, in a way, is water under the bridge. We now go to 70 and 71. Let's do that. I don't have all that much time. So if the court will look up paragraph 70 and 71 of Chavez-Vilches, it's tab 5 at MS 648. Now, I don't have time to read it again, but it's an important step-by-step instruction as to how to carry out the task in the case of children. 70 is probably concerned with the general position, that is, where there is no question of there being a parent who might remain in the United Kingdom able and willing to look after the child. So 70 gives you general instructions. 71 tells you how to carry out the assessment if there might be such a parent, if the argument is that there might be such a parent. So taking it the steps, the two paragraphs together tell the domestic court, one, to establish who is the primary carer. Got a comment about that, which is a difficult comment to make in what's left of 20 minutes, but it's important. Secondly, whether there's a relationship of dependency. Thirdly, that the ability of the other parent to provide care doesn't negate automatically the dependency. And fourthly, the member state has to carry out a detailed assessment of the sort set out in the last 5 or 6 lines of 71. So those 4 discrete points. How does the member state do that? We've tried to give an answer in our printed case, which is at MS 245. Now, paragraph 70 and 71 of Chavez-Vilches are plainly requiring an assessment under Article 7 of the Charter in order to see whether the right exists. So one of the difficulties about the use of the Charter doesn't arise. We know from Luxembourg authority that the assessment of whether the Zambano right exists is an operation in which the member state is actually within the scope of the treaties. What's involved in applying paragraph 24 of the Charter? Firstly, one needs to look, as we say in paragraph 18.2 of our printed case, Articles 3, 9, 12 and 13 of the UNCRC. The marginal notes give you the reference to that, but the most material of them, which is tab 51 of the authorities bundle, the most material of them are at MS 1770. I can't spend time now taking my lady and my lords to those provisions, but Article 9 of the UNCRC stresses the value to the child of contact and repeated relationships with both parents. That's what Article 9 is about. That is brought into play and is in play because Luxembourg Court has told us to apply Article 7 and the best interest formula, therefore Article 24 of the Charter. All of that is in play. My lady and my lords will also see that we have referred in the footnote, it's referred in 18.2 or 1, the importance of children's views, that's less relevant to this case, the facts of Shah, which I mean. Secondly, to the rationale for best interest, and then the footnote is important. It's a reference to paragraph 29 of General Comment 14, which is at tab 47 of the authorities bundle, MS 232, and paragraphs 28 and 29 stress the amount of weight to be given to best interests in these circumstances, and the obligation of the member state to demonstrate that it's carried out the exercise. I don't mean literally in a tick box way, but you should be able to tell from the relevant decisions that the member state has assessed the best interests of the children, of the child, having regard to all the matters listed in paragraph 71, and formed a conclusion about what the best interests require. Now, all of that is straightforward exegesis of what the Luxembourg Court has, what the Grand Chamber has said. Nothing additional or nothing that should in fact be complicated or controversial. Now, why are we doing this? That's the question that needs to be answered. The answer we give is that the member state has to make a decision of fact and degree of whether the impact on the child's best interest, having carried out this documented assessment, is such that the situation ought to be described as one in which the child is forced to leave the union, or whether it's actually still proper to describe the situation as one involving the mere fact of the desirability of maintaining family life. Those are the two ends of the spectrum, and you decide how to fit it in. And so we do say that if the best interest analysis points strongly to the maintenance of the family unit, that is either a strong or possibly conclusive indicator that the case is located, the case is not located at the mere desirability end of the spectrum. It's not a mere fact that it's desirable. Removal will constitute a strong, readily discernible breach of the best interest obligation. I've said already that when deciding whether the spectrum is respected, you look at the actual language the Luxembourg courts use many times. The word mere has considerable importance in this analysis. The last comment is on the injunction of the Luxembourg court to identify the primary carer. The court's seen that in paragraphs 70 and 71. With respect to the court, that has had a rather dated feel about it. There obviously will be situations in which you can spot another primary carer. Many of the complicated factual situations where the family is dysfunctional, where the family is not residing under one roof or whatever, there will be a primary carer. And the structure that paragraphs 70 and 71 envisage makes perfect sense. If you have a happy and functional family, which appears to be the position on the facts of Shah, although it's not for me to say, it's not immediately easy to see why one should identify a primary carer. The two parents are in it together, if that's an appropriate way of describing it. And in the modern world, one would hope that that was very often the situation. So how does our approach apply in relation to that? We say that if you carry out paragraph 70 and 71 analysis, you identify what are the best interests of the child concerned. In the unitary family, the happy, contented family, the best interest will point strongly, indeed very strongly, to the maintenance of that family unit and both parents playing a role. And so the answer to the factual question posed by paragraphs 70 and 71 of Chavez-Vilches is that if you're in that situation, you move beyond the mere fact of the desirability of maintaining family life into a situation where the member state concerned will form the view that the result of the best interest analysis are so clear that the child will be forced to leave the family together with both his parents in circumstances where the removal of one of them is carried out. That's a slightly rushed set of submissions, but that is the perspective we urge upon you, and I hope I've tried to grapple with the difficulties which I know are there. But that is, we have got to apply 70 and 71 of Chavez now, and that we have tried to spell out the steps that will be involved in carrying out that exercise. So, my lords, unless there's anything else on which I can help at this time.
Thank you very much, Mr. Travers. Yes, would you like to make a start?
Yeah, my lady,
Mr.
if I
London?
may, yes, just
Yes,
to
of
outline
course.
where I'm going at least. My ladies and my lords, by way of introduction, I'm proposing to advance the Secretary of State's case in response to these appeals in the following 5 stages. Can I headline what they are at the outset? First of all, a short summary of the issues that arise on the appeals, on our headline response to them. I was proposing to do that before the lunch break, but that might not now quite be possible. Secondly, an analysis of the case law prior to Chavez-Vilches. And the reason I'll do that is to show where the Court of Justice had reached in the development of the Zambrano doctrine at the point in time at which the appellants say there was a sea change in the legal position. Then thirdly, an analysis of the Chavez-Vilches decision itself, as well as the more recent KA Grand Chamber decision, which I say is important, in part in reconciling the Dept and Chavez-Vilches approaches and a consistency with the Court's earlier case law. Fourthly, a brief response to the points raised by the interveners and Mr. Patel as regards the Charter. And then fifthly and finally, in the conventional way, explaining why my submission, the Court of Appeal's approach here, was right on these particular cases. If that would at least assist the Court, that's the way in which I was proposing to do it. So can I begin by stage 1, which is a summary of the issues and our responses to them. See how far I can get by 1 o'clock. In my submission, there are 3 key issues which arise from the written cases and the oral argument as so far advanced today by the appellants and the interveners. The first of those issues is whether Chavez-Vilches has fundamentally changed the law on Article 20 TFEU and Zambrano, so that the test for engagement of a Zambrano right is now something less than compulsion. And we do say that although the appellants step away slightly from that formulation in their written case, that is in substance what they are asking for. Our answer to that question is no. On the contrary, both Chavez-Vilches and the more recent Grand Chamber decision in KA confirm the exceptional nature of the Zambrano right and further confirm that it only applies where the EU citizen in question is in fact compelled to leave the territory of the EU. We say that approach applies as much to cases involving children, whether in 2-parent family units or otherwise, as it does to adults. So that's the first issue. The second issue is whether the position of child and adult dependents is treated the same, in the same way under the case law. So Mr. Rowe for Patel argues that effectively Chavez-Vilches applies in exactly the same way. In my submission, the answer to that question is also no, as one can see perhaps most clearly from the Grand Chamber decision in KA. And then thirdly, my lady, the third of the 3 points is whether the Charter, or indeed any of the international instruments referred to by Liberty, alter that assessment. Again, in my submission, the short answer is no, they don't. Chavez-Vilches has confirmed that it's necessary to have regard to the best interests of the child. That much, of course, is clear and accepted. And indeed, it is entirely consistent with the approach taken in domestic immigration case law since at least this Court's decision in my Lady Hale's judgment in the leading case of ZH Tanzania. But the starting position, and we say the final position, is that unless there is compulsion to leave, the matter is outside the scope of EU law, so the Charter does not apply. We say that's consistent with the approaches in Dept and KA. My lady, I can develop those, I will develop those points, of course, in more detail after lunch, but those are the headline points as we say they exist. I'm not sure if I have maybe a minute or 2 left.
If you'd like it.
I'll take it, my lady, if I can in that case. My lady, in that case, can I stand back for a moment in those 2 minutes that are left, in the fray as it were, and just say this, emphasise this. This case concerns the scope of rights under the Zambrano principle. We say it has always been recognised by the CJEU and consistently repeated in the case law that the rights which arise under Zambrano are exceptional. We say they're exceptional because they exist at the very periphery of EU law. They exist at the periphery of EU law because unlike other forms of residence rights arising under EU law, they don't depend on the exercise of free movement. That makes them truly unique. And although Mr. Rowe said, well, actually, they protect citizenship rights and are therefore at the heart of EU law, in my submission, that is to confuse the substantive content of the right protected with the nature of the obligation imposed on member states in order to protect that right. So they are truly unique, and we say for that reason it's right to describe them as being at the periphery of EU law. And that's why in my submission the court has consistently described them as exceptional or arising in specific circumstances, to the point made by my Lord Sales. It's also why they're only recognised in circumstances where there is compulsion to leave. And it's also why they don't arise in the mere reduction of standard of living situation, the Harrison extreme, as Mr. Drabble put it, scenario. My lady, I'm very grateful for the extra 2 minutes, or the 2 minutes to 1 o'clock.
Oh.
Would that be a convenient moment to rise?
Very convenient.
Very grateful.
Thank you. Well, we'll adjourn now and look forward to hearing from you further at 2 o'clock.